climate change, and the 1.5 degree, the more ambitious goal of the Paris Agreement, that is 1.5 and 2 degrees. That's very much what's in view. So first of all, before I move to the European Central Bank, can I move this? It's not moving actually, so. Okay, so, but I need the slide in order to. Sorry, I can't with the keyboard. This is, no, this is stuck.
So sorry.
Okay, so before, in the meantime, so let me talk to you about today's topic. So I will talk about the monetary policy and greening the monetary policy of the central banks. Oh, yes, thank you. So this is now the legal concept. And the legal concept is the European Green Deal. And the European Green Deal, as we have it at present, doesn't talk very much about this central banks. So how do the central banks come in at this point? Because they may also have a role in climate change mitigation, climate change prevention, together with the other legal instruments. And this is the whole picture. So we have the Paris Agreement obliging to the member states, and the EU counts as a member state here, in making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. And to this end, we have a toolkit which includes the Corporate Sustainable Reporting Directive, the Sustainable Financial Disclosure Regulation, and in the middle, the so-called taxonomy regulation, which sets the standard for what is actually environmentally sustainable. And the latest part in this whole puzzle is the EU Green Bond Standard, which was adopted in 2023. Some of these provisions, especially the Corporate Sustainable Reporting Directive, but also in a way the Green Bonds Standard, they transcend the limits between corporate law and regulatory provisions and environmental law, because they look at the environment as such. So these reporting standards and the Green Bond Standards are not so much for investors, but these are disclosures that will whose finality is at least 50% of it is the environment as such. So, and in 2000, this is not completely new, because in 1992 already the Union introduced the EU Eco Label for environmental excellence in non-food products and services. So, without further ado, let me move to the rather unknown part, which is on the central banks. The central banks are and have always been gray eminences. So they're there, they provide, they care about the money supply of the markets, they set the standards for interest rates, but otherwise they're not so visible. They have been more visible in the last years because of the aftermath of the 2008 crisis. But of course, they have made many purchases, and the question arises whether about their role in purchasing bonds. And the question that I am going to address is whether these gray eminences are turning into green eminences, and if so, that this would in fact be an eminent development. So the legal instruments I've been talking about work not so much with prohibitions, but with rules, behavioral control of investors and of financial market actors. So how does the central bank come in here? So the goal of the European Union is to make brown bonds, and brown bonds is just a brief description of anything that's not green or environmentally sustainable, not socially and environmentally sustainable. So all these bonds are, in brief, referred to here as brown bonds. So at the moment, the issues of brown bonds don't need to be very much concerned about their attractiveness as long as they still sell on the markets. And as long as their purchasers interested in benefit from these bonds, they will sell in the markets. And everything depends a little bit on whether they are large-scale purchases. One of these large-scale purchases is the central bank. So a single purchaser whose green shift has a strong impact on the markets. So, and these are the central banks. But surprisingly, we have them here. So none of these rules, nor the Paris Agreement, nor the provisions of belong to the European Green Deal say a single word on the central banks. So the question arises as to whether the central banks can be fitted into these pictures and whether, if they deal with decarbonization, it is still monetary policy. The ECB and other central banks in the world have been purchasing bonds, and they have incrementally been purchasing green bonds too. And this occurs in their purchasing policy, and in the last years, as we all know, they have been adopting unconventional monetary policy to unblock the blocked financial transition mechanisms. So the gray balances appear to be turning green. And the blueprint for this may be the giant purchase programs that are now terminated, but that can resume with a green tinge. And this green tinge actually is visible in the lending policy and the purchasing policy, while purchasing and lending at the same time, of many central banks. And the European Central Bank is just one of them. Although it has been struggling with this, with establishing a strategic council so far, and I'll expound a little bit later why this is so. But central bank purchases can be important in the fight against climate change. But the problem we face is that there's no legal provision on all this. Why is there no legal provision? Because the central banks are completely independent in their policy, and so is the European Central Bank, which makes no exception. So the autonomy is there. And this is a little bit objectionable all the same, because any shift which is not entirely economically based interferes with the laws of the markets, especially when the purchase is large scale. So, but my central question is whether the central banks may commit themselves to decarbonization at all. Can monetary policy serve any purpose other than price stability? And if the answer is no, is such commitment lawful all the same if the Paris goals required? So is there room for sustainable monetary policy? Is there room for something like a monetary green bond as standard, or is that a contradiction per se? Let us start with the ultra-virus problem. This is a problem other central banks don't have in that so much, but the central bank hasn't. Why? Because it is subject to the principle of conferral. The principle of conferral is something that is typical of international organization that extends to the ECB as an institution within the ECB. And it says that anything not conferred on the European Union, and this includes the ECB by the treaty, is an ultra-virus act. And the ECB is entrusted with the monetary policy. That's what the treaty says. So where central banks exceed their powers, it is unlawful And this is not just a theoretical problem, because the European Union and with it, the ECB is under close scrutiny by the constitutional courts. And one of them, the strictest court, is the German Constitutional Court, which on one occasion, a few years ago, has declared a purchase policy of the European Central Bank unlawful. Or it does not say it is against the treaty. It says because it's against the treaty, we haven't endowed the European Central Bank to do so, and so this may not be respected by the German authorities. It's because it is against the principle of conferral. So it's not just a merely theoretical question whether the European Central Bank can go green or not. So in theory, there are three positions. So I don't find these provisions in legal literature, because the legal literature has paid too little attention to that. But so the position is highlighted in red. The possible position one is that the ECB is strictly confined to monetary policy. Monetary policy is for the money supply and for the interest rates on the market, so any preferential treatment of sustainable bonds would be unlawful under this position. The second position is that the central bank is under no constraint to adopt a sustainable monetary policy, but that after all, it is lawful and may be factored in, and that in that case, a preferential treatment of sustainable bonds would be lawful. And the third position, with a green background, is that the ECB is even obliged to do so. And in that case, the preferential treatment of sustainable bonds would be mandatory for the European central banks. So the answer depends a little bit on what monetary policy actually is. Back to this. So what is monetary policy? If you look at the laws, you won't find a clear answer, because few constitutions or laws define it. So the Australian Reserve Bank Act 1959 stipulates that the Reserve Bank is the central bank, okay, and that it boards, conducts the monetary policy. So much for this. The founding treaties of the European Union assigned monetary policy to the European Central Bank. I've repeatedly said this already, or to the European system of central banks. But there's no definition of monetary policy either. So we find the traditional instruments of monetary policy in the ECB statutes, open market lending, minimum reserve, and so on. Strikingly, the ECB never flagged its giant purchase programs as anything else but monetary policy, although doubts were cast on whether this was actually the case. It just said, well, we must bring inflation not down, but up at that time, and that this is also a goal of monetary policy. And we must prevent the single currency from failing, but this is a different story, which I'm not going to dwell upon. So, but in fact, the ECB has much, and like other central banks, there's something very much like a wild card, and it maxed it out after the financial crisis. And the question arises whether it can max out such a wild card in the purchase of green bonds. In any case, everywhere in the world, there has been a major change in the functions of the central bank. Before, it was just interest rates and price stability, money supply, and now in the meantime, since 2008, there have been guarantors of welfare, of living conditions. They have been future shaping. This is the role that central banks have taken on. The future may be a green future. So central banks have adopted programs on the purchase of green bonds. Even the Chinese central bank has done so. And the ECB adopted a climate action plan in 2028, replaced with a more sophisticated climate agenda 2022, to incorporate climate change considerations into its monetary policy framework. As the bank says, And but there were controversies among the board members on whether this is lawful or not, and whether it still complies with the entrusted mission. The ECB intimated we have the EU Green Bond Standard, and we have international non-binding standards by the ICMA on green, social, and sustainability bonds, and the ECB intimated that it would not follow exactly the one or the other, but that it would create its own monetary green bond standard on provided that the EU agrees on a green bond standards. So, and what could the future picture be? It could be in completely outlawing the acceptation of brown bonds, or it could be a qualitative or a quantitative privileging of green over or sustainable over brown bonds, or quota for each category. So what complicates things is that it's not necessarily green. Sustainability can also be yellow with social aspects, and these social aspects would not need to be factored in, and we don't have them in the EU Green Bond Standard. So there would be another standard would have to be put in place as well. So what seems to stand in the way is the monetary policy and the critical questions. So the crucial question, the most critical question, is whether this is still monetary policy. And this, I told you about this already, is what is unconventional still monetary policy because it's unconventional, or can monetary policy be unconventional? Because there's also a provision that says new instruments of monetary policy can be created by the European Central Bank. The ECB underpins that privileging green bonds is in the interest of the market actors because brown bonds are linked with the danger of disruptive events. So an oil spill, for example. But of course, this can also happen in green investments, just the explosion of a green hydrogen tank. So this is also disruptive. And climate change does not result from individual businesses, but of the accumulative effect, which is not per se disruptive, but steady and slow. If you ask me for a yardstick, I'd say that if environmental concerns such as carbon neutrality were to outweigh price stability, this would be a shift from monetary to environmental policy, and the central bank, especially the European Central Bank, could not do that. So the question remains if at least environmental concerns, sustainability concerns can be factored into the monetary policy, and there my answer would be yes. There's nothing in the wording. It says it conducts the monetary policy, provides support to the economic policies, because they still remain with the member states in the union, hence the plural, without prejudice to the objective price stability. But what we have is a so-called cross-section clause in Article 11, which talks about sustainability. The EU, everyone in the EU and all institutions in the EU have to commit themselves to sustainability in what they do. And this is why I think the monetary policy cannot be exempted here. And as a result, I'd say that it's rather in the middle, between the middle and position 3. So environmental aspects can be part of the monetary policy. And if there's not sufficient action in other fields, the ECB would even be obliged. So there's room for a green tinge, but not a green reshuffle, because in that case, the monetary policy would become environmental. Just a few words on what could be other obstacles here. So if we say that sustainable purchase, a specific sustainable purchase qualifies as monetary policy, because if no, it would be ultra-vires. If yes, market neutrality, price stability, and proportionality may pose obstacles. I'll just say a few words on them. Well, on the first two, proportionality is complicated here, so because that would be a different story still with PSPP. the former program. So market neutrality is an obstacle because several treaty provisions endorse it. So we have it in the treaty, and in principle, prioritizing green or sustainable over non-green or non-sustainable bonds, irrespective of their rating, would amount to interference with free competition, obviously. So, and but at the same time, we have Article 11, and we cannot completely disregard it. So, so there's at least room, in my view, for some preferential treatment of green bonds. And well, as regards price stability, the former governor of the German central bank a few months ago, in an interview, held that effective decarbonization would require higher CO2 prices, and there will be a price shift. But I think I wouldn't say that there's a risk of a greenflation altogether, because it would be a single shift in prices and in higher CO2 prices. And so the ECB need not refrain from green purchases as long as it can control price stability through money supply. So to summarize, the wildcards have been a bliss in recent years because they managed to tame, the central banks managed to tame the beast more swiftly than legislative measures could have done. And this could be also be the case with green policy. So the ECB came in as stabilizer of last resort. And so many expectations might therefore be attached to green purchasing by the central banks, which have gained in self-confidence, no doubt, but also in vulnerability because they're now under attack from some constitutional courts, and they're reproached as anti-democratic because they can do whatever they're independent. So we cannot await salvation for the central banks, but some future shaping the future. The ECB is not completely unchained. It's under control by the constitutional courts and must be cautious in changing paradigms from neutral to green. So it would probably not be halted by the Federal Constitutional Court, because the Federal Constitutional Court is also committed very much and very supportive to intergenerational equity and sustainability. So I don't expect another scenario where the Federal Constitutional Court declares this unconstitutional, but I expect opposition from the traditionalists within the European Central Bank, and so the outcome is still uncertain. But in any case, the European legislator would be well advised to seek a dialogue with the European Central Bank and vice versa, so that in the end, we will have one green bond standard and not various green bond standards, and that the problem we have with other legislative acts, which are not very well aligned to each other, does not arise in this field. Thank you.
I think we'll take questions at the end. And you need a mic.
Yeah.
We're going to take questions at the end, and I've put a note for those of you who are online just to send me through any questions in the chat box. So that would have come from Maywee, but just send the messages through and we'll ask them at the end.
Thank you very much. Well, thank you very much for having me. Now, after we heard about the ECB, we now want to know which financial instruments we're actually talking about. Now, as you know, considerable investments are needed to make society and the economy more sustainable and climate friendly. According to a 2018 estimate by the Intergovernmental Panel on Climate Change, limiting global warming to 1.5 degrees above pre-industrial levels by 2050 will require annual investments of 3.5 trillion US dollars. In the EU alone, annual investments of 466 billion euros are required. Now, in view of such sums, a successful transition to a low-carbon, climate-friendly economy can only be achieved with the help of private investments. The demand by private investors is growing steadily. According to the biannual report of the Global Sustainable Investment Alliance, global assets invested in sustainable financial assets amounted to 35.3 trillion US dollars in 2020, accounting for almost 36% of the total global assets of then 98.4 trillion US dollars. Due to some changes in how the US classifies sustainable investments, the number for 2022 dropped a bit to 30.3 trillion US dollars, about 24.4% of the total global assets of now about 124.5 trillion US dollars. In the following, I'll briefly discuss the reasons for the regulation of sustainable financial products in the EU, and we'll then have a look at the EU, how the EU implemented its ideas, focusing first on sustainable activities as the basis of the regulation, and then on sustainable financial products. Considering the increasing importance of sustainable investments for investors, as well as for the transformation of the economy, the EU has seen a need for regulating such sustainable investments. From an economic point of view, there would be no need for sustainability-related regulation of financial instruments if the real economy was efficiently regulated. More specifically, the environmental damage which we are concerned about, these do not occur in the financial markets, but in the real economy. That is where production and consumption takes place. That is where resources are consumed and pollutants are emitted. If the real economy was properly regulated, the costs associated with the production or consumption of these goods would be fully internalized by the producers, and then all environmental impacts associated with this production would then also be priced into the valuation of their financial instruments and could thus be taken into account by financial market participants when making their investments. However, this does not seem feasible for politicians, so we need one. Additionally, the considerations mentioned before regarding the pricing of sustainability risks require an efficient market. Studies indicate that non-sustainable financial investments are currently already priced with a discount. However, some assume that this discount is not sufficiently high yet and should be significantly higher. Consequently, there is a risk that even though non-sustainable economic activities should be unattractive for the real economy, this is not properly recognized by the capital market. One of the biggest hurdles that we see for investors and companies, and therefore also for the creation of a global market for sustainable investments, is that there is still no uniform understanding of when a financial instrument is sustainable. There are numerous, mostly private frameworks that establish their own standards and have different requirements. And there are also various standards by different countries. For example, if an airport operator were to issue a sustainable bond to promote a climate-neutral project, such as an emission-free airport building, this could be classified very differently. It could be classified as sustainable or green, because the building does not produce any environmentally harmful emissions. However, the building would support air traffic and aviation, which are responsible for 2.5% of global CO2 emissions. In this context, the problem of so-called green wishing can occur. If the airport operator considers whether his project is sustainable, he or she may be strongly convinced of his or her efforts, leading him or her to affirm its sustainability, even though there are more objective arguments speaking against that. Such kind of greenwashing is the first step towards the abusive conduct of so-called greenwashing. The term greenwashing describes when someone advertises a financial product as environmentally friendly in order to gain an unfair competitive advantage, even though it does not meet the basic environmental standards. Now, the German case of the DWS subsidiary of Deutsche Bank shows that this is not just a theoretical problem. Investigators started to target DWS after the former head of sustainability at DWS had made greenwashing allegations against the firm to the Wall Street Journal in the summer of 2021. According to her, and contrary to the information published by the DWS funds, ESG factors were not taken into account or only in a minority of investments. Such practices undermine investor confidence in sustainable financial products and ultimately damage the EU's goal of making the EU economy more sustainable. To address these developments, the EU has adopted a raft of regulatory measures. We already saw some of them. The starting point is the action plan Financing Sustainable Growth, with the European Commission published in 2018. This action plan ties in with the United Nations Paris Climate Agreement of 2015 and aims to create a sustainable finance system. In 2019, the Commission incorporated these envisioned approaches into its European Green Deal. Two key legal measures that have been adopted for the financial markets as part of the implementation of these plans are the Sustainable Finance Disclosure Regulation and the so-called Taxonomy Regulation. The Sustainable Finance Disclosure Regulation obliges financial market participants and financial advisors to disclose information on sustainable investments and sustainability risks regarding the company and the financial products they offer. The Taxonomy Regulation is intended to create a standardized EU-wide classification system to classify economic activities as sustainable or non-sustainable. The Taxonomy Regulation is supplemented by various delegated regulations that further specify the principles set out in the Taxonomy Regulation. The reference point for the classification as sustainable in the context of these regulations are not financial products, but the economic activities of the companies. This does not refer to the sector or industry of a company, but to the individual economic activity, such as forestry or the production of batteries. And these activities are to be determined on the basis of a very European statistical classification of economic activities called the NATSE codes. In the context of the EU financial regulation, the sustainability is understood in the sense of ESG, as you know, environmental, social, and governance. The disclosure regulation defines the term sustainable investment as an investment in an economic activity that contributes to an environmental objective, or an investment in an economic activity that contributes to a social objective, provided that such investments do no significant harm to any of those objectives and that the investee company follow good corporate governance. In contrast, the taxonomy regulation focuses on environmentally sustainable investments. According to Article 2 of the taxonomy regulation, these are investments in one or more economic activities that qualify as environmentally sustainable under the taxonomy regulation. Then, according to Article 3 of the taxonomy regulation, these activities must contribute substantially to one or more of the environmental objectives or not significantly harm any of these objectives, and must be carried out in compliance, in particular, with human rights and occupational health and safety regulation, and then also meet specific requirements defined by the Commission. We have a total of 6 environmental objectives that are listed in the taxonomy regulation. These are climate change mitigation, climate change adaptation, the sustainable use and protection of water and marine resources, the transition to a circular economy, pollution and prevention and control, and the protection and restoration of biodiversity and ecosystems. In the subsequent articles, it is explained in more detail and defined qualitatively which details constitute a significant contribution to each of these goals. In addition, the Commission delegated regulations specify various parts of the taxonomy regulation, and here it gets quite complex. For example, just the delegated regulation that specifies the first two environmental objectives in more detail consists of about 350 pages. For an economic activity to be sustainable, it also has to meet the requirement that environmental objectives other than those directly pursued must not be significantly harmed by that activity. Together with the delegated acts, the taxonomy regulation specifies for each climate objective when a significant adverse effect is to be assumed. For example, a significant harm to climate change mitigation has to be assumed if the activity leads to significant greenhouse gas emissions. As you'll probably know, significant needs to be concretized in more detail, and we see that in the then delegated regulation. The taxonomy regulation itself does not say anything about when these emissions are significant. You will find that in the delegated regulation. The taxonomy regulation and the corresponding delegated regulations of the Commission only focus on the environmental sustainability right now. This narrow focus reflects the concentration of sustainability law on the ecological aspects, so the E in ESG. Although S and G are mentioned as aspects to be considered as well, they do not receive the same level of attention by the EU, at least at the moment. We see some work on a social taxonomy, but this has been postponed, and we're not sure if this will ever come, whether the next Commission will actually then also focus on these aspects or not. Well, this does not only ignore the strong interdependence of the three ESG factors, but also contradicts the regulatory objectives of the EU, which repeatedly emphasize that all three sustainability dimensions must be weighted equally. Based on the economic activity, which can be invested in through a financial instrument, it can be determined whether the respective financial product is also sustainable. Financial products within the meaning of the regulation that we discuss here are especially investment funds, insurance products, and various pension products. Generally speaking, these financial products are forms of investments which an intermediary invests in after collecting capital from investors or policyholders. Shares, bonds, and other financial instruments in that regard are not covered here, only these collective products. And for bonds, as we heard, we have now the brand new EU Green Bonds regulation. By determining the economic activities can only be classified as environmentally sustainable or not sustainable, like either or. Financial products can also be sustainable if they only partially invest into financial in certain companies issued, and that these companies which actually, only partly invest their money or their activities into these sustainable activities. While it's rather easy to determine whether an investment or a company that one invests in should be considered sustainable if the company only pursues one economic activity, it becomes more difficult if the company pursues several different economic activities. Now, for example, how would you deal with an electricity provider that has is emitting, generating electricity from coal and from renewable energies? So to determine the degree of this environmental sustainability, it can be best to look at the share of the economically, environmentally sustainable economic activity in the company's total turnover. We don't have any minimum thresholds or maximum values in that regard. Like, for example, quantitative specifications to determine whether any proportion of the environmentally sustainable investments of a financial product are sufficiently high or not. So there is still some very important part lacking. To sum it up, regarding the increasing importance of the market for sustainable and financial investments and the difficulties in pricing sustainable financial investments correctly, as well as the confusion among investors and companies about what constitutes a sustainable financial product and the associated risk of greenwishing and greenwashing, there are some valid reasons for the EU to regulate sustainable financial products. The EU wants to create a legal certainty regarding the concept of sustainability, which is difficult to grasp actually in legal terms. However, the overall regulation of the taxonomy regulation and its delegated regulations will likely fail to meet that goal. The mass and the meticulous attention to detail of the regulations, which are intended to cover every aspect, are likely to lead to even greater need for legal advice and will have a deterrent effect for companies and investors alike. The reference point for determining sustainability according to the Sustainable Finance Disclosure Regulation and the Taxonomy Regulation is not financial products, but rather economic activities. While that might be a comprehensible approach, it also leads to increased complexity in determining whether a financial product is sustainable. And fourth, financial products can be environmentally sustainable, even if they only partially invest in environmentally sustainable economic activities. The sustainability of financial products is to be determined based on the proportion of the investments in sustainable economic activities. In the legal acts regulating the financial markets, the term sustainability is understood as ESG, but we focus mainly on the E. And finally, the taxonomy regulation does not contain any minimum thresholds, which makes it even harder actually to determine whether we have a financial instrument that's sustainable or not. Well, thank you very much.
Christoph and Jörn Axel, thank you so much. We're going to have some time for questions at this point. I've already announced to the people who are online, please send through a message if you have a question. Do we have any questions in the room? Oh, my colleague Steve Carabas, go for it, Steve.
Thank you. That was great. Thank you very much. I was just going to ask about the central bank and green bonds and just a little bit more of the justification for the thinking behind it potentially being prohibited, because it still seems like monetary policy. It's just that they're deciding to go green, but it's still monetary policy. So I was just wondering if you can expand a little bit on the potential reasoning.
Yes, thank you very much. I think this is a very important question. So I'll try to emulate the doubts that have been cast by others. So my doubts are not so don't weigh so much. So, I think it's behind the EU policy, because the EU views its policy when it comes to sustainability as environmental policy, at least in part. And this is why, for example, the directive on sustainability and disclosure that applies to the company, where, by the way, we have 3 European sustainability reporting standards that are social, so maybe that will trickle in with over time. So this is, half of it is environmental law, and it's based not just on the internal markets provisions, but also on the provisions that enable the EU to do lawmaking in environmental policy. But the central bank is confined by the treaty to monetary policy and the support to economic policy to the extent that it does not negatively affect its mission in the area of monetary policy. And so the argument behind it is that if the treaty remains silent on this issue, because the treaty expressly stipulates that the EU has to conduct the monetary policy, and the economic policy is in the hands of other bodies, namely the EU legislator, not the ECB. That's why some say that the EU may not conduct anything that's focus is on the environment, because what the EU does in terms of sustainability is divided. Some of it refers to the companies or investors, and the other part refers to environment as such. And to the extent that the environment as such isn't the focus, the ECB is prevented from factoring in environmental concerns. I say, well, my personal opinion is that this is not altogether persuasive, because we have the Article 11, which stipulates that everyone in the EU has to, in conducting its own policy, has to give due account to environmental concerns and sustainability. But it's that purely environmental element that leads to the objections. And we have it in some other legal instruments as well, because they look at the environment and not at the market. And to the extent that they look at the environment, the ECB may not use this, may not resort to this in its policy. That's the main argument against it. But there are not many persons who have expressed their opinions on that yet.
You don't have a comment on that, Christoph?
Well, I think the target
Yeah,
the
it's
ECB
very
mainly.
hard.
So
Any other questions in the room? I'm not seeing any
There's-
online.
I think there.
Oh, you are, yeah. Alan.
Thank you for such a wonderful speech. I mean, two of them. So I have observed in the past, in the recent years, that in Australia, there is a pushback on the ESG agenda. So I think similarly, I think, I have spoken to people in the States, and they made a very similar observation. So my question to you guys, what's the situation like in the EU or in Germany in particular?
Well, if you look to Germany, I think we don't see it in the way we see it, for example, in the US, some very aggressive anti-ESG activists. Actually, we see, like this year, we have the first initiatives to actually implement this ESG idea into the charter of various companies. So we even see companies and their investors taking that up and trying to actually, bring it to the very front of their own doing. There might be some that try to actually do something against that. We do see activists in numerous cases with numerous agendas. However, we still have many companies with block holdings, which are very important. For example, if you see Volkswagen, it's very likely that you get anything there, because you have like Porsche with a huge stake in there. We have the state of Lower Saxony, who has with about 20% stake in there. So those have already 70%. Even if you would oppose that as a small investor, they could still go through with what they want. That is different than other cases where you have a more dispersed ownership, but still you have a very strong part on like investment funds and pension funds being investors in these companies. And when you hear that, for example, Larry Fink from BlackRock told that they would actually look into this ESG very fondly and wanted that, I think that is probably more important than some smaller investors that try to oppose that.
So maybe just some brief follow-up remarks. So the one is from the perspective of SMEs. I think they haven't quite grasped what's in the pipeline for them. So, and I think this needs to be, this is not very well known yet, and some of these rules are very, only have been adopted very recently. So, and the other remark is on politics. I think politics are divided on this, and even the German government is divided. While on the one hand, there's a strong green impact as the Greens are in the government, and they are so very supportive of some of these legal instruments. The Liberals, who are also in the government, have, for example, they prevented a few weeks ago a rather strict form of the supply chain directive, which would have obliged the undertakings to report on human rights violations in the supply chain. So this is already the yes part, but I think it belongs in the picture.
So we have that on the policy side. So we don't need this in the investor side, the opposition.
Alan Shaw. Alan.
Thank you both for the presentation. My question is addressed, I think, at first instance to Christoph. The difficulty or pitfall I think you identified was a divergence in understanding of what sustainability means, but the taxonomy regulation sets out in a lot of detail what it intends by sustainability. So can you explain a bit why there are still divergent views and what those divergences are?
Okay, wonderful question. For example, if you take the EU Green Bond Regulation that Axel mentioned briefly, so the Green Bond Regulation actually takes the taxonomy regulation and says we base all our sustainability related definitions on the taxonomy regulation. However, because that's so complex, there are already banks that seem to be a bit worrying a bit about that. And the EU Green Bond Regulation is an optional instrument. The regulator said they would actually, if you want to name your bond a European green bond, if you want to use this label, then you have to adhere to the EU Green Bond Regulation. However, if you don't want this label and you just call yourself, I don't know, ICMA Green Bond, then you could refer to the ICMA Green Bond principles. And these Green Bond principles are, let's say, on a very high level, very abstract, not very detailed, and very pragmatic. So you could still use these Green Bond principles, have a green bond, but you don't call it European Green Bond. And so we will still have a divergence with regard to green bonds if you really don't make sure that this is a European green bond. So there's still, I think the European Union was a bit unsure whether they should actually pursue this completely and actually say we have only green bonds in the European Union that are European green bonds. They had this somewhere in the middle of the way. And I think in the parliament, they tried to get rid of this again because they were anxious that then afterwards nobody would actually go for green bonds. And they said, we make it optional. So that's why we will still have divergences afterwards.
Just a brief comment on this. I think this must be also seen from the perspective of power politics, because, at first sight, it appears to be the sovereignty of Parliament, in that case, the European Parliament, when it adopts all these rules. But the true legislator is the European Commission, because as Christoph said, these rules, although they appear to be very exhaustive, are vague. It's the European Commission and the delegated legislative acts that adopts the true rules, for example, on atomic energy and whether it's sustainable or not, which is very controversial in the European Union, as we may believe. So it's who has the say, the European Commission, the Parliament, or the European Central Bank? And this may also explain why the European Central Bank is a little bit cautious in adopting what the European Commission has actually adopted, not the European Parliament. And there's also, I think, this is also on whether ICMA or the European Commission has the say on what's actually sustainable. So it's a complex network of powers in the background.
Kelvin, Kelvin, over to you.
Thanks, everyone. My question follows pretty closely in the wake of Alan's, and I think the issues have already been touched on, but I might seek to draw this point out further. Bear with me, it's a bit of a long one. So I understand the EU has sought to define what is environmentally friendly and sustainable and create a degree of standardization by introducing the taxonomy. This consistency could then facilitate more informed decision-making by investors. That said, could it also have the unintended consequence of stifling innovation if it's too prescriptive and doesn't leave enough room for more granular differentiation? So based on the way you've described the regime, it seems quite binary, black and white. It's either sustainable or it's not. And if so, this seems to create an incentive to do just the bare minimum to fall on the sustainable side of the line and no more. Christoph, that might be best fielded by you at first instance.
Yeah.
That wasn't that long. That was,
No, I was waiting to get more. Yeah, you are right. The problem is, I think the details, the Commission got very granular. So they even wrote, how much, I don't know, hectare on such and such, I don't know, years you need to cultivate to be on this side or that side. So I think even the how they measure the emissions that you have to produce is very intricate there. However, with regard to whether that is stifling or not, you have these like NACE codes. These are certain activities that they have standardized. However, whenever you have a new activity that is not falling under these NACE codes, you are somehow outside of the realm of the taxonomy regulation. So then they need to be introduced to the NSCA codes, and then the Commission has then delegated regulation on them to actually somehow sort out what the requirements are for these new activities. So in a certain way, that is open for future development, but it's also a little bit, difficult to actually pursue that, because you always have to see whether there is a new activity and whether you can actually then draw up all the requirements for this activity. In that way, it might be difficult if you have a new activity and you would like to be sustainable, because you cannot fall under the taxonomy regulation. And that means that then the investment funds or pension funds will not invest in your green bond, because, well, you're not actually have an activity that is green or can be green because it's not being defined. So in that respect, that probably hinders very quick developments. But in the end, since you can add these activities, it's not stifling completely. So we'll see how that plays out, but there's an important question.
One remark on that too. So, well, here I think the proof will be in the pudding again, and what the European Commission will legislate is the wrong word. Will the rules the European Commission may adopt, and so my prediction is that it will be not too strict in adopting rating an activity as sustainable, because otherwise it will have negatively affect that business. And the question remains, and have no persuasive answer at this point, whether a business can sue the European Commission before the European Court of Justice for not rating its activity as sustainable, or for not rating at the right time. So whether the purchases by financial investors, or the preventing financial investors from purchasing these bonds is sufficient to consider this business as negatively affected in its rights it has under European Union law. So there are many open questions, and there may be lawsuits in the future, but this is hard to predict.
Right, and may I add just that the German KfW, this state-owned bank that is actually very active in the field of issuing green bonds. They have issued, I think, green bonds worth of like 70 billion euros last year. And they said publicly that as of now, they are not sure whether they will actually use this green bond standard based on the taxonomy regulation. So they probably will, use the ICMA green bond principle or something like that, which are more pragmatic and easier to use, and still it's green. So, if even the state-owned banks are kind of reluctant, we'll have to see how that plays out.
We're going to wrap up in a few minutes, but I do have a question going back, I think, Christoph, your point about greenwashing and how it's discovered. And I think you gave an example of a whistleblower, and I've forgotten the organization. Was it Deutsche Bank?
It's a subsidiary of the Deutsche Bank, yeah, right. DWS, it's a fund. Right.
So I'm interested in, whether all the jurisdictions have the same whistleblower laws, because some jurisdictions, whistleblowers are much more protected than others outside of Europe. And also, I recall in the US that sometimes misleading and deceptive advertising of firms, came to the attention of the regulator because competitors would call them out over it. So I'm interested, how protective are whistleblower laws in Europe, and have you had examples of competitors saying, well, they're saying they're green, but they're not?
Well, actually, we have a new regime on whistleblowers. We have a directive which is, I think, very stringent in that regard. They try to do a lot. I'm not sure. I think the German take on that was to, drive it back a bit. But nevertheless, within the European Union, we have this quite very new directive on that.
I'll say a word on this because I'm the editor of a commentary on that, the German whistleblowing law. So we have the EU whistleblower directive. Directive means it has to be transposed into national law, and this directive applies only to violations of EU law. So the scope is rather broad, but it's confined to EU law. And the German law transposes the directive. The German law was adopted a year ago, transposes the directive. It had to be transposed into all national laws. So there's a common basis, but only a common basis with regard to EU law. And the directive is rather vague in some of its articles. So the national legislation may vary. And this German whistleblowing law is more comprehensive in that it encompasses violations of German law that's not based on European law as well. So it's a very comprehensive instrument, and other states may have different laws and may be confined to violations of EU law, and even in that they may diverge.
And do you find that culturally there are differences in attitude to whistleblowers in different countries in continental Europe? I mean, I know that with the VW scandal, it was, the finger was pointed at too much worker loyalty. Is it seen as very disloyal, do you think, culturally in parts of Europe for a whistleblower to report their company?
I'd assume. So I didn't know of research being done on this, but I would be surprised if that weren't the case, because we have seen even where the laws are more harmonizing than the whistleblowing directive, for example, in the European Data Protection Regulation, which applies the same in all member states, we have differing cultures of data protection in the member states. So it's applied very strictly in Germany, and in a less strict, albeit not sloppy manner in the Scandinavian states. They have a different tradition, and I believe it must be very much alike when it comes to whistleblowing.
I think
that captures it. Well, I think that's the wrap. I'd like to thank our speakers, Axel and Christoph, very much. That was really fascinating. I'd also like to thank Monash Sustainable Development Institute, MSDI, for partnering with CLARS for this event. And particular thanks go to May Wee, who has been fantastic. I think she's not in the room. Oh, yes, she is in the room. Hi, May. She's been fantastic in, doing the background stuff to make the seminar come together. As well as I'd like to thank Tony Capon and Rob Raven from MSDI for being so enthusiastic when I first contacted them and told them that we would have these exceptional scholars in town. So just to finish off, I think, May, you've got a website that people can sign on to MSDI if they would like to. The centre that I'm director of is the Centre for Commercial Law and Regulatory Studies, or CLARS, C-L-A-R-S. And if you Google that, you can also sign on to our mailing list. But we look forward to future seminars with you, May, and thank you again. And thank you all for coming and being a great audience.